How are you today?
Do you have permission to be on this property?
Can I get your name and badge?
No, you can't. I need your ID, please.
Do you have your ID?
Do you have your ID? I need to see your ID. Are you refusing to
commit
ID
a crime?
yourself?
Did I commit a crime?
You're failing to ID
Did
yourself.
I commit a crime?
You are failing to ID yourself.
Did I commit a crime?
I'm going to go ahead and detain you for right now, please.
Hello, and welcome back to Legal Dissent, where we evaluate your constitutional rights before they're taken away. We hope you are enjoying the content we are creating, and if you find it entertaining or informational, please do support our channel by subscribing and liking our videos. It truly does help us out a lot. Today, we evaluate the audit of 51-55-0 as she is filming the exterior of a refinery located in Shelbyville, Indiana. We evaluated one of her audits just a few weeks ago where she did a wonderful job. The link to her channel, the original video, all of the case law and statutes are located in the description below. Please check out her channel and let her know that Legal Dissent sent you. 51-50-50 starts the video on the side of a county highway in Shelby County, Indiana, and tells us briefly about an encounter she just had with the refinery's employees.
A lady in a white van came and told me that I'm on their property and that I had to leave. And I said, no, thank you. And she said the sheriff will be here in a minute.
Several minutes go by and she begins to engage with her live audience who is commenting on her video, and this leads to her first mistake.
I'm not sure where I am, Preston. I don't think I'm in Kentucky.
If you are in the business of auditing or in a situation that is likely to lead to an encounter with law enforcement, please know where you are before you start auditing. Each state has different rules and regulations, and you need to know the law to ensure that you are not violating a law that will enable law enforcement to arrest you. In this instance, the auditor states she does not know where she is, but she doesn't think she's in Kentucky. Which is correct. She's in Shelbyville, Indiana, just southeast of Indianapolis and a good 100 miles north of the Kentucky border. If you do not know where you are, you don't know which law might apply to you. So please make sure to do your homework before auditing.
I don't know. Billy, she just said she did. Hello. No, thank you. I'm just getting some pictures. How are you today?
You can't be on this property taking pictures, man.
I'm on public property.
This is actually public property.
Several feet back it is, but this is public property right here.
We're all the way from here on.
The auditor is correct. She is currently on public property. All highways in the state of Indiana create an apparent right-of-way. An apparent right-of-way is defined in Indiana Code Section 8-20-1-15.5 as the location and the width of county highway right-of-way. This right-of-way generally is 20 feet from the center line and is used for the purpose of utilities, drainage, and public safety. While the GIS from the Shelby County Recorder does not clearly show if there's an easement recorded for this portion of highway, I would be shocked if there was not an easement located here, as public utilities are located on the other side of the street.
No.
Sheriff's on his way, so he'll let you.
Yeah, that's fine. Thank you.
Hi, if you don't mind, please put
I
that
do.
down.
I do.
Well, you're not allowed to record
Then get away
me
from me.
if you don't.
Then get away. Get away from me. Get away from me. You don't
I'm
like
sorry,
it? Get away
but
from me.
this is our
Don't like
property.
it? Get away from me.
As we have discussed before, you do not have a reasonable expectation of privacy in public. Anything you do or say in public can be recorded legally. At this point, the employees back away. A few more minutes pass by before a large semi-truck turns onto the road. We point this out because the auditor has been formally charged with 4 crimes, one of them being obstructing traffic due to this right here. The probable cause affidavit filed by Sergeant Lacy of the Shelby County Sheriff's Department claims that the auditor would cause traffic to have to swerve around her and enter oncoming traffic to pass by her. Video taken by the auditor prior to law enforcement arrival and posted to the website YouTube shows a semi leaving the ethanol plant and having to enter oncoming traffic to avoid Harrison, where she was standing in the roadway. Indiana Code Section 35-44.1-2-13 defines that the obstruction of traffic occurs when a person who, with the intent to obstruct vehicular or pedestrian traffic, obstructs vehicular or pedestrian traffic, commits obstruction of traffic. Now, I'm not a traffic flow expert, but to me, it doesn't seem that she has the intent to obstruct traffic. And in fact, she doesn't even obstruct the traffic. The semi is taking the wide turn because of the white SUV parked by the employee and not her on the side of the road. All of this is a huge reach by law enforcement and reeks of retaliatory charging to punish someone for not respecting their authority. In fact, these charges were not even filed until well after they had found the YouTube channel that she has and watched the YouTube video.
Hey, you're obstructing some traffic, man.
I got lights.
Yeah, you do.
If I want. You have an ID?
For what?
Well, obviously got a call on you.
First, this is Officer Brinkman, badge number 113. The hypocrisy of Officer Brinkman as he is clearly taking up half of the highway to address the auditor, and then later having the gall to recommend charging her for the obstruction of traffic, is mind-boggling. Next, and this is why it is so important as an auditor to know what jurisdiction you are in and what law applies. The officer's statement, quote, "Obviously, I got a call on you," end quote, is not a valid reason to demand someone's identification in Indiana by itself. The state of Indiana does criminalize the refusal to identify in Indiana Code Section 34-28-5-3.5. This statute does create an obligation on citizens to identify to police, but only if a law enforcement officer has stopped the person for an infraction or an ordinance violation. At this point, the officer has not stopped her for a criminal act, and she does not have an obligation to identify yet. However, this would be a fight in court. I believe she would win it, but ultimately, it's up to a jury to decide, because legally, it could go either way. Per his report, Brinkman was dispatched to a suspicious person standing in a roadway, filming and taking pictures in front of Poet on 300 North. While on my way there, dispatch advised the female subject was arguing with subjects from Poet and she had been trespassing. Now, I believe this gets the officer close to a reasonable articulable suspicion, but not quite there yet. As many of you know, the United States Supreme Court held in Terry v. Ohio that a police officer may reasonably detain a citizen temporarily if the officer has a reasonable suspicion that a person has committed, is committing, or is about to commit a crime. We always ask for the officer's reasonable articulable suspicion when they attempt to detain and identify. In this instance, the officer can only point to the witness's statements, claiming that she was in the roadway, she was trespassing, and then finding her on the side of the road when he arrived. If the statement had been that she was on our property or on the parking lot, etc., or if the officer had found her on the property, then he would clearly have his reasonable articulable suspicion. However, the statements made by the witnesses claim she was in the roadway in the police report. The officer found her in the easement to the roadway, and that easement is public property. A competent officer should be able to know that filming on a roadway is not in and of itself a crime or reasonable articulable suspicion of one. Unless there is evidence of the auditor being actually on the private property of the refinery, the officer does not have reasonable articulable suspicion. However, this would be a fight in court and not a slam dunk win because of a couple of reasons. First, it's going to depend on what those witnesses will testify to under oath in court, but also because Indiana has also enacted the Good Faith Belief Act in Code Section 34-28-5-3, which provides whenever a law enforcement officer believes in good faith that a person has committed an infraction or ordinance violation, the law enforcement may detain that person for a time sufficient to basically identify that individual. This allows an officer to identify a person whenever they, in good faith, believe that someone has committed a crime. A court would most likely maintain that the officer was operating in good faith by believing the witnesses who called in the complaint over the auditor. In the 2010 Indiana Court of Appeals case Starr v. State, the court held that a passenger of a vehicle stopped for a traffic infraction does not have to identify unless the officer has reasonable suspicion that the passenger is actually committing a crime. Reasonable suspicion is a relatively low standard of proof, significantly less stringent than the probable cause standard required for an arrest. Reasonable suspicion requires a 50-50 chance that someone may have committed a crime, which, in this case, based on the statements made by the Poet employees, a court may very well rule that the officer was acting in good faith and had reasonable suspicion per the police report that she has been trespassing. I believe there are good arguments to be made on both sides, and ultimately it'll be decided in a court of law.
What are you doing out here?
I'm taking pictures.
Why?
And then they came bothering me.
Why?
Wanted to. Can I get your name and badge number?
Well, when we get done, I'll give it to you. No problem. What's...
I'm just taking pictures.
You have a license with you?
Why would you want that?
Oh, because I have right ID. I'm here on a call, man.
Did I commit a crime? Did I commit a crime?
I didn't say you did.
Then why would you want my ID?
Oh, do you own that property right there? Huh? Do you own this?
Now, here is evidence that really begins to help the auditor combat the earlier good faith doctrine and reasonable suspicion. It's definitely still not a slam dunk, but you can use it to begin picking away at the credibility of the officer. Note that when the auditor asks if she has committed a crime, his response is, "I didn't say you did." He then starts looking for that reasonable articulable suspicion. This officer is clearly not the cream of the crop of the police academy. If his report is accurate, then he doesn't need more of a reason than independent eyewitnesses issuing a complaint claiming that the auditor was trespassing on their land. However, he doesn't seem to know that in this encounter, so at this point, he may not have his reasonable articulable suspicion to identify her. But then, the auditor makes a massive mistake. She has parked her car on private property across the street from where she is auditing. If your goal is to avoid being identified, don't park your car where they can easily find it, run your plates, and ID you. Just like you have the right to film anything within the public arena, officers have the right to run your plates that you are exposing to the public eye.
Ma'am, I have a right to get your plate too. This is not your property. Seriously, why make this?
Why are you bothering me? Why?
They called.
That's their problem. I'm taking pictures of that property, and I'm standing on public property, bothering no one, and it's not a crime. It's a First Amendment right, and I can exercise it if I want to.
Okay, it's a crime for you to park your car here.
Really?
Yeah. Do you own this property?
Here's where the situation gets really sticky. The land that she has parked on belongs to someone other than Poet, the refinery which she was originally filming, and the entity that made the complaint to the police. The owner of this property has not complained, and to our knowledge was not aware of the situation at all. This information becomes huge later on.
I'm not here to argue with you. I'm here because I got called. We get off in 25 minutes.
That's their problem if I'm not committing a crime.
You are now.
Really?
Do you own this property? Seriously. You don't. I mean, whatever your issue is with them, that's fine. That's
I don't have an issue with them. I was taking pictures.
Okay.
Okay.
Well, sounds like me you're recording. Or it looks like you're recording.
There is no legal ramification to be made by the distinction of taking pictures or recording.
The video, yeah.
Okay.
Same as like many
That's
pictures
fine.
in a row.
That's fine.
Yeah. It is fine. So this isn't necessary.
I mean,
Maybe you should let them know what's public property, and that anybody can take pictures or video anywhere on public property of anything that they can see from public view, period. And there's nothing else about it, because that's a...
As long as you're not obstructing traffic.
I wasn't.
Did I say you were?
I said I wasn't.
Okay.
I can talk without you asking me a question.
Okay.
Yeah.
But you don't own this property. So you need to go. You got something.
Officer Brinkman's statements again will aid the auditor in court. He obviously has no knowledge of any traffic obstruction, actual property entry to constitute a trespass, and he does not even know if this is the auditor's car or not. At this point, Sergeant Lacy arrives on the scene, and the situation has escalated very quickly. We'd like to point out a couple of things about Sergeant Lacy. First, in 2005, this man shot and killed an individual after a traffic stop. We'll be doing a video later on about Sergeant Lacy going into more detail about that situation that happened earlier in his career. But we wanted to point it out so that way you knew who this auditor was dealing with when she went face to face with a killer just a few days ago.
Do you have permission to be on this property?
How are you today?
Do you have permission to be on this property?
Can I get your name and badge?
No, you can't. I need your ID, please. Do you have your ID? Do you have your ID? I need to see your ID. Are you refusing to ID yourself?
Did I commit a crime?
You're failing to ID
Did
yourself.
I commit a crime?
You are failing to ID yourself.
Did I commit a crime?
I'm going to go ahead and detain you for right now, please. Okay? You're failing to identify yourself. You're being detained because you're failing to ID yourself. I asked for your ID. Are you refusing to ID yourself?
Did I commit a crime?
Are you refusing to ID yourself?
Did I commit a crime?
Yes, you did. Failing to ID yourself.
Failing to ID yourself is not a crime in Indiana unless you have been stopped for an infraction or an ordinance violation, and he cannot arrest her for that unless there is an initial charge.
Did I commit a crime?
Failing to ID yourself. Okay?
That's a secondary charge. Did I commit a crime?
Yes, you did. You're trespassing. Do you have permission to be on this property? Okay? So, no problem. You're failing to ID yourself? No problem.
Now we are getting to the root of the issue: trespassing. The auditor was ultimately charged with 4 different crimes, 2 of which revolve around criminal trespass. The first, and more consequential, is the felony trespass onto a critical infrastructure facility. A refinery, per Indiana Code 35-46-10-1, is considered a critical infrastructure facility. Therefore, if she was found knowingly or intentionally entering the property of Poet without their permission, she's guilty of the crime. There is no warning necessary for an individual to be convicted of this in Indiana. However, based off of the footage we have, I do not believe she ever entered their property and stayed on public property on the easement throughout the entire encounter. If Poet or the police are able to uncover evidence that proves she was on their property, this obviously would change the outcome of the situation. On to the second trespass charge, which they charged under Indiana Code Section 35-43-2-2-B1, which defines trespass as a person who, not having a contractual interest in the property, knowingly or intentionally enters the real property of another person after having been denied entry by the other person or that person's agent. This is in regard to her parking her car on the property across the street from the refinery. This parcel of land is an agriculturally zoned piece of property and is owned by an individual separate from Poet. The auditor has several arguments here that would work in court. First is obvious. She didn't knowingly or intentionally enter the property and believed it was public due to the presence of public utilities around her vehicle and the fact that it was designated for parking without any trespass or keep out signs posted. Second, and even more convincing, is the argument that the statute requires the trespasser to have been denied entry by the owner or the owner's agent. Throughout Indiana, this is the law. You are entitled to a trespass warning before you are arrested for trespassing. The property owner has not issued a trespass warning to the auditor and is not even aware that anything is going on his property. The appropriate response here is that the officers should find out who owns this land, contact them, and ask if the owner wants them trespassed or not. Then let her leave peacefully. But the officers are taking it upon themselves to punish this auditor for her failure to respect their badges. This is wrong, and this charge should not hold up in court.
Okay. So you're not going to ID yourself? Is that what you're saying? So we can do this. Okay, you're failing to ID yourself. I'm requesting you to ID yourself. You're not doing it.
Did I commit a crime?
Yes, you did. You're trespassing. This is not your property or anything of the case. You do not have permission to be on this property.
Whose property is it?
Not yours.
Really?
Yes.
Whose is it?
I'll tell you that. Okay, this is not your property. Okay? So, you want to do it this way? This way we'll do it. Okay? You're going to be arrested for failing to identify yourself.
The officer clearly has no idea who owns this property and is assuming that the auditor doesn't. But hang on, as the assumptions get even wilder.
We're here. We got a complaint. You're not on public property or private property.
I walked over here because he
Is
walked
this
over
private
here.
property?
I walked over here with him. I walked over here with you. I was on public property.
Is your car on
Public
public
property. I was on public property, and they called you.
No problem.
I walked over here with him.
Okay, you got arrested because you failed to identify yourself. You're
For what
required by
crime?
law.
What was I arrested for? What was I arrested for?
Trespassing.
What,
You have to
what
ID.
property owner called you and said to trespass her?
Man, do you own this property?
Do
just
you?
can't come in.
Do you?
And a click on a computer, we
okay.
can find out who owns it. I
I
guarantee
can
it's
do.
not going to be you.
Okay?
Did
No
a property
problem.
owner call and say, have this woman off my
No
property?
problem.
Did you? Did that happen?
Okay. I told you what's going on. I asked you to identify yourself before we even touched that. You failed to identify yourself.
I didn't commit a crime.
You're as far as you're
I didn't
wanted.
commit a crime.
You're wanted.
I'm wanted.
You're wanted.
For what?
How do I know? You
What
won't
are
tell me
you
your
talking
name.
about?
You have warrants because you're not telling me who you are. So I'm assuming you're
That's
wanted.
insane. That's insane.
This is unbelievable. This is unprofessional, and this is wrong. You're wanted, you have warrants because you won't identify, therefore you're wanted. I'm beyond words. This is 2021. This didn't happen years ago before officers knew they were going to wind up on YouTube for saying stupid stuff. This happened less than a week ago, and we still have law enforcement making claims like you are wanted and have warrants because you won't bow down to my authority and identify.
Insane
Okay.
logic. That's insane.
No problem.
I don't have to.
Where's
If
your
I
ID
committed a
at?
crime.
Where's your driver's license?
Where's your driver's
Where's
license?
this car parked? I have the inventory and I need to ID
Your
you.
car's getting towed and everything else. Is this the way you want to do it?
I didn't commit a crime.
You failed to identify yourself.
I didn't commit a crime.
You failed to
ID it
identify
you.
yourself.
I did not do anything wrong.
See those cameras in the car? This is
Yes.
all being recorded too. So,
Great.
all right. So no problem.
I didn't commit a crime to be
Sure you
arrested
did.
for.
Okay. I wanted to ID yourself because I want to make sure you have permission to be on this property. You got permission from your homeowner?
So you arrest people and then you investigate?
Yeah, okay.
I tried. You wouldn't do it.
The auditor is correct. This behavior is insane. Arresting people based off of assumptions and emotion is not good law enforcement. The auditor posted a follow-up a couple of days ago, letting us know she's out on bail and that she has been charged. While I think the officers obviously went overboard and did a lot of things wrong, the auditor also messed up too. Know where you are. Know which state laws you're being governed by. Don't park your car right where it's so easily found by law enforcement, and do a quick GIS search to make sure you're actually on public property before asserting that you are. Now, I think she has some really good arguments in court to defend her case and beat the charges. That being said, I don't think she has a great argument for a lawsuit because of the good faith exception in Indiana. The courts will most likely find that the officers did act in good faith and that they had enough evidence to give them reasonable, articulable suspicion that she had committed the crime of trespassing on Poet's property. However, the officers were absolutely wrong in this situation. They escalated the situation far beyond where it needed to go. Officer Brinkman did not know what he was talking about and made foolish assumptions without even investigating the situation. Sergeant Lacy is dangerous. Just seeing the look in his eyes, the anger, and the emotional outburst conducted by him in the situation makes me feel afraid. This is not what law enforcement is about. We understand that human beings have human emotions, but you need to keep them in check when you have a badge and a gun. You must not use your emotions to destroy people's lives. Your job is to serve the community, not to drag it down. What do you guys think? Am I wrong? Let us know in the comments below, and we'll see you next time right here on Legal Dissent.